Welcome everyone. This is the meeting of the Sentencing Guidelines Commission. The date is April 13th, 2023, and it is really hot out there. And I don't know about you guys, but my office was like sweltering today. Yes. But I'm not going to complain, honestly. It's been really quite lovely. We are conducting this meeting as a hybrid meeting today pursuant to state law. And I will go ahead and ask our Director Wrights to please do the roll call, please.
Roll call, Vice Chair Estrada.
Present.
Estrada present. Ibrahim. Ibrahim absent. Knudsen.
Present.
Knudsen present. Ladd.
Present.
Ladd present. Larkin. Larkin absent. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell. Schnell absent. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 7 members present, 3 members absent, 1 seat vacant.
All right, great. The first item on the agenda is approval of the draft agenda. I would entertain a motion to approve the agenda. Commissioner Middlebrook moves it, and Commissioner Moore seconds. Any discussion on the agenda? Hearing none, please go ahead and take the vote.
To the Middlebrook motion to approve the agenda, Estrada?
Yes.
Estrada, yes. Ibrahim? Ibrahim absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, no votes opposed.
And with that, the motion is approved unanimously, so the draft agenda, the meeting agenda is approved. Third item on the agenda is recognition of outgoing commission members. All right, so we have two folks that we want to recognize today. The first is Commissioner Tanya Hanzi. Tanya was appointed by Governor Walz on April 23rd, 2019 as one of our public members. And she brought a unique perspective to the commission as a person who's been directly impacted by the criminal justice system. I really valued her input as we talked about issues like custody status, the probation, the presumptive probation issue. I really think having someone on the commission who has experienced the system is valuable for us as commission members. And so I really appreciated having her attend the meetings and participate in our discussions. Tanya was unable to attend the meeting today because she's working out of town, but she wanted to thank the commission. She said it in an email, "It has been a joy and honor to work on the commission for the last 4 years alongside the other commission members. I could not be more proud of the work we have done around the probation cap." So we're going to be honoring her with a certificate, and I just want to take a moment to thank Tanya for her service. The second person that we have to recognize as an outgoing member is Commissioner Estrada, Valerie Estrada. I don't know if I'm going to hold it together through this one, to be honest, because you've become a friend, not just a commission member. So give me a moment here. So I'll say the formal stuff, and maybe that'll get me to a place where I can actually say the nice stuff. Governor Mark Dayton appointed Valerie Estrada as our probation officer member. It's not working. I'm going to stand up because that will help me. Okay. I don't know, it helps me. Anyway.
Oh, excuse me, ma'am.
Yes, Commissioner
I think there's a clear indication that she is not allowed to
She isn't reappointed.
That's right. So I'm not going to do this. Yes, thank you. All right, so Commissioner Estrada was appointed by Governor Dayton October 12th, 2016. She began on the commission as a career probation officer with Hennepin County Community Corrections, and she was reappointed by Governor Tim Walz in 2019 after having been promoted as a corrections unit supervisor for Hennepin County. Valerie was elected to the commission as the commission's vice chair by unanimous consent on November 5th, 2020. Over Valerie's time on the commission, her probation experience has been really invaluable. Some of the issues that she's participated in were the commission's response to the 2016 Drug Sentencing Reform Act, the demographic impact statement policy, the 5-year probation cap, the review of the guidelines criminal history score, which actually predates me, and the initiation of a sentencing guidelines neutrality review with an emphasis on the impact by race. I think in the time I've been here, I've really watched you grow in this position as well. And it's been great because I think that, you know, understanding what's happening in the probation system is just so important for the commission, because if we look at our statistics, most people who are convicted of felonies end up on probation. That's just the fact. So we really do have to understand what is happening in that system. I think that we couldn't have had better input than the input that you've provided over the past few years. I've really appreciated you being vice chair to sort of help me think through some of the issues and approaches for how the commission should take them up. It's really been valuable to me to have you work with me on these issues. I'm going to miss you, but we're still going to do happy hour from time to time because I don't want to give that up. But I just want to thank you for your service. To recognize you, we have a lovely plaque. Congratulations thank you for being on the commission, and congratulations. Yes.
Now it's my turn to try to hold it together. I just want to say first, thank you to both governors for the opportunity. I have also seen growth. I remember coming in and being so intimidated, like, oh my God, I'm around like appellate court judges and I'm around the chief public defender and what am I doing here? And
Now that I can't imagine.
Exactly, right? So I come a long way from being that woman who walked in with, I don't know what to say, I don't even know Robert's rule of laws, to be able to, or order, to be able to really speak. It's been a great opportunity. I have to also thank my organization, Hennepin County, my area directors here, for the support. This, as you all know, takes a lot of work and it's time away from our work. And throughout the six and a half years, I've had that encouragement and that empowerment of having confidence in myself, as well as the MACAC board of directors as well, who has consistently provided feedback on the many issues that we have taken up. The staff of the Minnesota Sentencing Guidelines that are here and are online, you all are wonderful. It does not go unnoticed that when we come to these meetings, we have this lovely report and this presentation of data that is not easy to interpret. And the amount of work that goes into that, it is not always the easiest commission to say, well, we want this and we want this and we want that. And you always deliver. Thank you for that. And then to all of the commission members, it's been an honor working with all of you. This is a space in which we are experts in the positions that we hold, and we all have a common goal, and we may have different ways of getting there, but the conversations that we have, the discussions that we have, and some that are very colorful, are in the best interest of our clients, our victims, and our community at whole. And I appreciate all of your experience in helping me grow in that. So thank you all. Thank you, Chair. Thank you, Director. This has been an honor that I will take with me forever. So appreciate you all.
Did you want want to say anything, Julie? Not to put you on the spot.
You know, we've honored Valerie in various ways throughout her career. And this is another one of those transition points to more significant leadership in our organization. What you gave here to the state of Minnesota, I echo what everybody said, is invaluable. Thank you for committing to it and for committing to not just be here for you, but to represent all of corrections across Minnesota. You really did that in outstanding and first time outstanding. Really appreciate it.
Any other comments? All right. Well, that all being said, I mean, you're great and all, but we're gonna put you to work. And we just have a couple more pieces of work to have you participate in today. All right, so that's item 3. We'll move on to item 4, which is approval of the draft meeting minutes from March 9th, 2023. You should have all had a chance to review those minutes, and I would entertain a motion to approve the minutes from March 9th.
So moved.
Commissioner Estrada makes that motion. Commissioner Knudsen seconds. Any discussion? Hearing none, we'll go ahead and take the vote on that.
To the Estrada motion to move to adopt the March 9th, 2023 meeting minutes. Estrada?
Yes.
Estrada, yes. Ibrahim?
Oh, he is.
Ibrahim?
Doesn't have a little microphone next to his name.
We don't, let me see if I can, you're unmuted. How about a thumbs up or a thumbs down? All right, Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Do you want to take a minute to try to troubleshoot Commissioner Ibrahim's sound?
Well, I can tell you that I think I started to hear something. No, maybe not.
We do love looking at the baby though.
Yeah. No kidding.
You can always bring the baby to the meeting.
That's awesome. Well, it's, I would say it's probably something on your computer just because as far as WebEx is concerned, you're unmuted. So we should be able to hear you, Officer Ibrahim. So I guess.
Can you hear me now?
Oh, yeah, there we go.
Yeah, there we go.
Oh, there we go. Okay, sounds like we heard you there. So you can go back to mute and, unless you have something else to say. But, all right.
Okay, let's see. Sorry, my computer is it's a bad technology day for me today. So my WebEx is not where it normally is, and it's hard for me to switch between WebEx and the agenda. Okay, the next item is improving the commission's meeting calendar. I'll turn that over to Nate for discussion.
Thank you, Madam Chair. So if you were here in the December meeting, you'll recall that we talked about the meeting calendar in the context of changing the rules that govern our meetings. And those are rules that the commission adopted back in the 80s. And those rules require a formal public hearing before guidelines changes. And the real problem really has to do with that summertime public hearing because the typical pattern, almost every year that I've been here, and I think long before that, is that there's, the legislature changes laws. For example, the legislature has adopted a new crime involving possession of used detached catalytic converters. And so the commission then will have the responsibility to rank that crime on the sentencing guidelines grids. And then that has to go to a formal public hearing, which because of the publication requirements and the time required, takes 6 weeks in the summer calendar. So there's kind of this 6-week gap. And then that's followed by a formal public hearing. Then there has to be another delay of about a week to allow written comments, and all because of the commission's meeting rules. And then finally, in late July, sometimes a couple of days before the publication of the August 1st sentencing guidelines, the commission meets and does final approval. Linda looked back at the last 8 years of those summertime public hearings and found that the most public comment we ever got for one of those was 2, either written or in person or both. Never got more than 2 public comments at one of those hearings. So it's a very lightly attended public comment, as opposed to some of the late year public hearings that we've had where they're commission initiatives, as opposed to responses to legislation, where in some cases we've had full rooms of people who were interested in commenting on proposed actions by the commission. So we thought it might be possible to streamline the calendar. And so we did discuss that, I'd say briefly in December, but what I'd like to do now is drill down a little bit on the calendar that we had proposed to you back in December and talk about some of the pluses and minuses of that proposal, and maybe get some ideas that the commission might have on a calendar. The whole idea being, before we embark on this rulemaking process to change the rules that require this formal public hearing, first the commission should really kind of decide that it wants to change the calendar. If it's fine with the calendar that it is, as it is, we don't need to change the rules. I mean, there are some archaic things in the rules, but it certainly would be less urgent to change the rules. So that's the context for this presentation, Madam Chair, is really just looking at.
And let me interject too, that even if we decide today that we're interested in changing the calendar, that we're talking about, all that does is move us into a rulemaking phase where we might review the rules and make changes to the rules, but no changes to the calendar will happen until any rules are approved and adopted down the road.
Right.
So like, none of this changes anything this year.
That's
This
true.
is relevant.
No, I think maybe if we acted quickly, we could change the 2024 meeting calendar, but the 2023 meeting calendar is as it is, I'm sure.
Yep.
So the so this is the staff paper that I gave. I'd like to first talk about the current meeting calendar, just point out a few things about it. And I'm going to start in the summer. It's a little bit out of sequence, but so the June regular meeting is the Thursday after the first Tuesday. The first Tuesday is, if I've done the math right, the governor's action to act on bills in a regular session. So we should know what the new laws are by the first Tuesday in June, and then 2 days later, we have our meeting to sort of respond to those laws. And then exactly 6 weeks after that, and I could break down the 6 weeks for you, but it's required because of the publication, the 30-day notice period and the publication deadlines and all that. But 6 weeks after that, we have our commission meeting, the third Thursday in July, and then the fourth Thursday in July, which July 22nd through 28th, which again can be very close to that August 1st guidelines publication. I think in some cases, if August 1st is a weekend, I think it might actually be the day before, if I'm not mistaken. But that's when the July regular meeting takes place. So what that does is it kind of slows down the momentum, I would say, of the commission's work. It's always going to be interrupted because of the response to the legislative action, but it's kind of doubly interrupted by that 6 week delay. Then you get the public hearing and the meeting, and then you take the month of August off. So by the time you're back in September, October, November, that's when you start getting back in the groove again. But it does feel like we lose a little momentum there. At least that's my perception. And then in December, right now, the Thursday after the second Saturday, we have a public hearing and a regular meeting right now scheduled on one day. That regular meeting cannot take action on what was heard at the public hearing. It has to be the January meeting, just because there is that 5-day public comment period afterwards. So, and then going back to January, you have a meeting 3 or 4 weeks after that, January 8th through 14th. In most years, the report to the legislature is due the next day. So what has to happen at the January meeting is final action taken on the public hearing, if there was a public hearing, and then finalize the report to the legislature, which has to include not only the action that you just took, finalizing the public hearing, if you change the guidelines, that has to be in there, but anything you want to write up about that. So one year, Justice Dietzen on the drug reform had some things that he wanted to say about the rationale for the drug reform. Makes sense? Not unreasonable, but the problem was, since it had just been adopted, there wasn't really any time to run that language past the commission. So it was problematic that year. So that's one problem with the regular meeting. Plus, it's pretty hard on staff to have to put out the report to the legislature, finalize it, do all the editing, make sure it's all correct, and then send it out to the legislature all in one day, especially if there were a number of changes that the commission made the day before. So those are kind of some flaws in the current meeting schedule, and I talk about that in here. There's also this special session issue where if, as happened in 2021, the legislature doesn't finish their work in the regular session, but instead pushes off work into the special session, it ends up, there's not much flexibility in the schedule. It's really hard to do things. It's actually impossible to do things in time for an August 1st publication, given our current meeting rules. So what we ended up having to do, I kind of think it's the tail wagging the dog there, but we asked the legislature, could you postpone the effective date on those laws to September 15th rather than August 1st? And the legislature graciously complied. But, but that was something the legislature had to do because of our meeting rules. And I'm sorry if I sound like I'm an advocate here. I'm just trying to point out the pros and cons. The September meeting often conflicts with the judges. They have a educational conference, my understanding, after the Labor Day. And
but that's changed.
Was that changed?
Yeah, it's moved to the end of September.
Oh, it's moved to the end of September. Oh, so this might actually conflict with that.
Right.
Okay,
It's going to depend on the month or the year, I think.
okay. I was not aware of that. Let's see. Sounds like we might have a hot mic in the room. I don't know if everybody's unmuted. I can unmute everybody if not. All right, so let me just stop the presentation for a moment. Okay.
This coming year, it's September 26th to the 29th.
Okay, and that might conflict with the staff suggestion was to make it the Thursday after the third Saturday, and the date range would be September 20th through 26th. So it's possible there might be some conflicts there.
Well, just as a side note, if I might, the County Attorneys Association has their fall conference the same time the judges do, because the judges aren't available for court, then it gives us space to do our business too. So that would also be a conflict for me,
Okay,
so,
well, if anybody
or
can
somebody
tell,
that's in this position.
if anybody can tell me what the formula is for that might be helpful. But
Well, like you said, it always used to be the week
After Labor
Day.
Yeah.
But then we got much better rates to go at the end of September, so starting last year, 2 years ago,
It's been a couple of years,
Yeah.
at least.
Okay.
one at the end.
And the other conference that's like that is the December conference, where the county attorneys and possibly the public defenders all meet because the judges are meeting, so it's, there's no
And
court.
Yeah, that's always done like the first week in December.
Yeah, so, and we'll talk about that a little bit on the, let me talk about the staff suggested calendar. So and I'll start with the public hearing. So the staff suggestion is just to have one public hearing, and this would be the public hearing for commission initiatives only, not for response to legislation. The staff suggestion is that there wouldn't be a public hearing for the legislation per se. There would just be an opportunity to submit comments before the meeting, an opportunity to make oral comments at the meeting. And as we've discussed, that's not going to take up a lot of time typically. There's not much in the way of public comment for these responsive changes. And then the commission could just go ahead and act without any particular waiting period. So it could just be between two meetings that takes place. But for this annual public hearing, which I've got on our staff proposal, we have as Thursday after Thanksgiving. So that could be as early as November 29th, as late as December 5th. So 1 week after Thanksgiving would be the public hearing. And then 1 or 2 weeks later, the commission would meet to take action. And whether it's 1 or 2 weeks would depend on when the judicial conference is. My understanding is that the judicial conference, right now, the formula is that it starts on the first Wednesday of December. So this would be the Thursday after the second Wednesday of September, so as to always deconflict with the judicial conference. And that's when the commission would take final action on the public hearing. So that would be splitting up the two things that we do. Yes. Sorry.
Thank you. Director Rades, I guess I'm just curious, if there's only one, the annual public hearing, what do we do if there's new crimes and we have to rank them and they would go into effect August 1st? Can we still do that even with only having the informal public comments?
Not under our current meeting rules.
Okay.
But
Right,
it's
so
our rules.
That's exactly the problem. The current meeting rules do not allow that. So you would have to change through administrative rulemaking,
That's, okay.
which is what we would embark on for the next several months, I imagine, going through this administrative rulemaking process. If you want to change that to make it a more streamlined process, where you just basically put out a notice on our website or email sort of thing, and whatever you end up deciding is the new process, but not with having the public hearing. So it would just be a regular meeting where people could come and give comments. They could give written comments in advance, and then it really wouldn't be that dissimilar to how the legislature does it, where they allow people to submit things in writing, they allow people to testify, and then they make a decision. That's kind of how the commission would do it.
Let me just say that I think the missing piece here, I think I asked you to resend it, but I don't know that we got it again, is the memo you wrote last December, which is what are the requirements in the law? Because our rules are one thing, but the state law is what we really have to comply with, right? We can change the rules, but we can't change state law. And the state law requires a public hearing or something, requires us to send that through for changes that decrease sentences on the grid or something like that. I can't remember what the language is, but the ranking decisions are not in there as. It's just that we've created a procedure that has the same public input process for both types of changes to the guidelines.
Right. So that's a good question. Let me pull up the law.
I'll further editorialize while he's doing that. So, if we have to send our change through the legislature for them to review before it goes into effect, that is not a change that we have the ability to make instantly, right? But these other just ranking decisions at the end of the legislative session are not things that we have to send back through the legislature. So that's really the difference here. And when the commission was created, though, they created the law requires us to have rules for how we do this, but we created one set of rules for all of the changes.
Yeah, and the statute is, the structure is a little confusing, just reading it, but basically there are two kinds of things that the legislature needs to submit to the legislature on January 15th. That's really the focus of subdivision 11. So if it amends the sentencing guidelines grid, including severity levels and criminal history scores, or it would result in the reduction of any sentence or in the early release of an inmate. So let's just pause here and take carjacking. Carjacking would qualify, right? Because you'd be amending a severity level. You'd be adding a new severity level for carjacking. So carjacking would fit under this clause so far. But it says, with the exception of a modification mandated or authorized by the legislature or relating to a crime created or amended by the legislature in the preceding session. So all of a sudden carjacking's out of that because it's a new law. It just got created by the legislature in the preceding session. So it's not, so what's about to follow does not apply to that. But that shall be submitted to the legislature by January 15th of any year in which the commission wishes the change to be effective, and shall be effective on August 1st of that year, unless the legislature provides by law otherwise. So what the statute is saying is there's a delay. So if you decided instead of ranking carjacking, did I say carjacking? I'm sorry. I'm talking about catalytic converter theft. But carjacking is just another new crime that was proposed. So that's, I think, why I had it on my mind. So catalytic converter theft, you'd have to rank it. But let's say instead the commission decided it wanted to increase the severity level for aggravated robbery, change the severity level for aggravated robbery. So then, since that's not something that the legislature took action on, that's going to be very delayed. It has to be submitted to the legislature by January 15th, and it won't take effect until August 1st of next year. So if the commission today decided they wanted to change something, nothing would happen until August 1st of 2024, because it's not in response to a legislative change. And it doesn't say anything about a public hearing at that point. It just says it has to be pre-submitted to the legislature so that the legislature has the entire session to look at it and say whether, if they don't like it, they can override it. All other modifications, so this sentence applies to all other modifications, which because of that exception includes all modifications that were that relate to a crime that was created or amended by the legislature in the preceding session, or a change that's mandated or authorized by the legislature. All other modifications shall take effect according to the procedural rules of the commission. So what that's saying is it's really up to the commission on how and when and what processes are involved in changing things that don't need legislative pre-clearance. And that's what we have right now. In that summertime public hearing, we have the June meeting, take initial action, public hearing in mid-July, final meeting in late July, takes effect August 1st. And that's really all it says, is that the modification shall take effect according to the procedural rules of the commission. So that's the question, is does the commission think it should change the procedural rules? So this is the public hearing that we have because the procedural rules now require it. And I'm assuming that the commission will want to continue the formal public hearing with the formal notice going forward for these commission initiatives, the ones that have to be pre-cleared by the legislature by January 15th. And that's the purpose of the Thursday after the Thanksgiving annual public hearing, November 29th through December 5th. And then at the following meeting, the December 9th through 15th meeting, 1 to 2 weeks later, that's when there'd be final action taken. And I'm hoping that deconflicts with the judicial conference. And then going back to the top of the calendar, then we'd have a January meeting 3 or 4 weeks later. This is moved up a little bit, January 4th through the 10th. It's possible January 4th could conflict with some holiday schedules. I don't know. So if, say, New Year's Day were a Monday, January 4th would be that Thursday. That would be the earliest possible meeting. But the purpose for having it that early is because that gives staff more than one day in every case to finalize the report to the legislature. So we'd have at least 4 days to finalize the report to the legislature. And the main purpose, at least from my perspective, from staff's perspective, the main thing that we'd want the commission to do in that January meeting is finalize the report to the legislature. That would be it. There wouldn't be any policy being made, I wouldn't imagine, at that January meeting. And then we'd have, because that's a little bit earlier, that would have us move to the first Thursday of the month for the following 4 meetings. The June meeting would be the second Thursday. So the summertime schedule would be a little more relaxed. It'd be 5 or 6 weeks apart for meetings, but we'd still be continuing to meet. And I'm hoping, my hope on this calendar, and this, this is not the only calendar you could do, but my hope on this calendar is that would kind of keep the momentum going of any discussions that the commission was having in the spring. I will say this August regular meeting, the August 21st to 27th, that's always a week and a half before Labor Day. So it won't conflict with any holidays. It's I think of it as the state fair meeting. But the problem with this meeting is it would sometimes conflict with the annual Criminal Justice Institute that's put on by the Bar Association or the CLE. So, and I know some of us attend that pretty regularly for our continuing legal education credits. And there would be a conflict with that sometimes under this calendar.
Commissioner Knudsen.
And when is that again? Is it a dedicated week or?
I don't know what their formula is for that, but I just looked on historical schedules and matched it up to this, and sometimes it conflicted and sometimes it didn't. So I don't know whether it would usually conflict or not.
Seems like it's always that week.
Yeah.
I don't know.
And then, so that is a problem with this. And I guess now it's a problem, now that we know that the judicial branch has moved theirs back. That might be a problem too, that September 20th through 26th. But really, starting in the August meeting, I know these seem like obscure dates, Thursday after the third Friday, the Thursday after the third Saturday. These are all kind of backing up from Thanksgiving. So Thanksgiving is kind of the key date. So these are all exactly 5 weeks before Thanksgiving, 4 weeks before that, 4 weeks before that, and so forth. So it all lines up with the public hearing that takes place a week after Thanksgiving. So that's the purpose of that fall schedule. And then we start over again. So
Commissioner Moore.
Madam Chair, Director Wrights, I think when there are 5 Saturdays in September, by my calculations, that's where there wouldn't be a problem with that calendar. But if there's 4 Saturdays, if you're meeting after the third Saturday, as I understand would be the proposal, that would be the last week of September, which would potentially conflict with the judges' conference. I will say that not every judge goes to that every year. Some judges frankly don't go at all. And, Zoom could be an option too for participation. So, I see this calendar as being really kind of, connected to certain dates. And I guess I'm not, obviously if the county attorneys are meeting at the same time, there's another factor there too. That September meeting date might not be, it won't be a conflict every year. Let's put it that way. It'll be conflicts some years.
I do think, if I'm not mistaken, I think Judge Mark did beam in remotely one time for that conference when it conflicted with the commission's meeting date. So that's always a possibility. So
Commissioner Knudsen has a comment.
And the other one I'm looking at is the Judicial Council. And that is generally the third Thursday of every month. And again, it's just hit and miss, like if there's any members that have that conflict. But I would.
Well, you're not the first person on the Judicial Council to also serve on the Sentencing Guidelines Commission. So that's something I hadn't thought about either.
Except there are two exceptions to that, the judicial council schedule. So it's, you think, why are we doing all this? And I understand we're trying to match up and make sure we can meet our obligations, have the public hearing, then take action and all the rest of that. And sometimes I think it's just out of our control. I mean, you think of the legislature having special sessions and not passing laws until late in the summer or even in the fall, and then we've got to respond to it. So it's some of those public hearings, we can move around and kind of adjust as we expect. And let me just take a dumb example. So my Rotary meetings, we, over COVID, we went every other. So we know for sure it's always the second Thursday and the fourth Thursday of the month. And judicial council is always the third, basically, the third Thursday. And I think that's done out of a concern that it's consistent. People can put it on their calendar from year to year. It's kind of the same. You know what it is. And particularly for an organization, this commission that is responsive to the public and the legislature, is there a consistent meeting time that others can count on, that they kind of know and they can schedule, they can set their meetings in their internal offices to clearly correspond? Well, it's always going to be the second Thursday or the first Thursday of the month in general. Which doesn't mean we can't have special meetings or we can't schedule our public hearings to respond to the work that we need to do. But I just want to think about that.
Okay.
Well, I would say, I respectfully disagree about the public hearing issue, just because the requirements that we created in our rules, which I don't disagree with, to provide adequate notice to people that that we are taking up an issue that they might want to comment on. The 6-week time frame it's a 6-week time frame, 6 to 7 week time frame. So it's actually quite a lengthy process, and it's not something we can do like on a dime, right? So it does, and we've had to schedule public hearings at weird times and schedule our meetings at weird times, but like all of these actions also require quorums. So it does get really difficult to take action when we need to take action, if we can't plan for it on the calendar. I think this discussion is actually backwards, because it's not about the calendar so much, it is about the calendar. The rules affect the calendar, which has put us in this place where for several years in a row, we'll work on an issue, we totally lose momentum on that issue, we try to come back to work on that issue, we forgot everything we did in the spring, and then we don't have enough time to finish the issue. Because we had this big break in the middle to deal with rankings. And rankings are important, and people should have input on those as well, but they usually don't provide input on the rankings after we've made those decisions. So the question is, what level of process do we need to ensure adequate input when we're making those ranking decisions? And one possibility is that the level of process that maybe all we need is a notice and comment period during that, summer, so that we can actually continue to do our other work at the same time, rather than taking a break to do the big public hearing thing as well. So I don't, in no way would I ever suggest that we don't get input on those rankings decisions, because we definitely should, and we have changed our minds based on that input before. So we should have input, but what form does it have to take? Right now, we've set it up as a public hearing when mostly people don't come to those. The other stuff that we do, the policy work that we do, we get a lot of attendance at. And so, definitely we would want to keep that level of process for all of the policy work. The question is, do we need that for the annual rankings as well?
Well, and
Commissioner Knudsen.
So it seems to me that we can set our annual public meeting. Since I've been on the board, we have one, within 2 weeks or within a week of our regular meeting. Or as you're suggesting, we don't get a lot of comments, we can combine the annual meeting, we can put that on the calendar, have that as the placeholder where we make those certain decisions and solicit public opinion as part of our regular meeting.
Right.
So I'm not saying that these public meetings aren't important or that we can just set them whenever we want to. I think they do have to be set and they do have to be scheduled, but they can be either added between regular meetings or added as part of a regular meeting. And then when we do the other work that requires, or we want public feedback on, those are the public meetings or the public forums where we can schedule in a time that we think gives enough notice and gives us enough time to submit whatever to the legislature.
Okay, so are you saying that, sorry, I just want to clarify. So you're saying that maybe we shouldn't have a set date for the public hearings? Is that what you're suggesting?
No, I think we have to.
Oh, okay.
So we have to have that public hearing and to correspond with our response to the legislature for any work that we need, correct?
Right now, yes. That's, wait, do you mean which, are you talking about the response at the end of the session or the policy work that we do?
Response at the end of the session.
Okay, right, so right now our rules do require a public hearing for that, yes.
Right. And so we should have that set, but then what happens is we can't do that work because they want a special session and they can pass the bill or we have to wait and get the schedule, that kind of thing. But anyway, I think we should have the public hearing on our calendar and have that set.
Okay, so I'm suggesting something completely different, which is not to have a public hearing for those decisions. But we would have to engage in rulemaking to make that change.
Oh.
To say instead that it's like a notice and comment period. So we would do our normal ranking decisions at the first meeting we can after the session ends, put those decisions out for public comment. At a later meeting, then we would make final decisions, but there wouldn't be a hearing, a formal hearing in there anywhere. But people could come and testify at a regular meeting if they wanted to.
Right. Well, I'm in agreement with that. But then the annual public meeting that we're scheduling is for what purpose?
Policy work.
Policy work.
Yeah.
We don't know when we'll be prepared or when we're going to have that or when we want to convene a public hearing for response to that, correct?
Well, we know that we have to submit a report to the legislature by January 15th every year. So we can bet that if there's any policy changes that we want to report to the legislature, the latest we could have that hearing would be that November, December timeframe.
Oh.
So that's what I think, Dave's
so
just banking that most of the time we have something that's in that category, right? So then that's where we would set our annual public hearing.
Okay. But we don't know if we will.
Right, if we don't have anything, there's no hearing that year.
Madam Chair.
Yeah.
And when I took this job, there wasn't let's say a summer public hearing and winter public hearing. The summer public hearing was on the calendar because we can predict that there will be some changes in response to the legislature. The winter public hearing was not on the calendar, but then it would always be a surprise. The commission would have an initiative this year and then we'd have to shuffle things around. And that's why there is now a public hearing / meeting on the calendar. But I would say in the 8 years I've been here, it's been more often than not that the commission has some initiative that it would like to put into the guidelines that's not in response to something the legislature did. But that's why I call it a commission initiative. And so we've had to do public hearings. So my thought is just put it on the calendar. If we don't need it, which is quite possible, the commission doesn't have to have an initiative in a given year. But if we need it, it'll be there and the calendar will support it.
Commissioner Estrada and then Commissioner Lett.
I don't know how much I have to say because this is my last meeting, but what I have to say is I do like the proposal of having the annual public hearing at the end because typically something comes out of this commission that's going to require, typically in the last 6 years that I've been here. I also appreciate the possibility of the rankings allowing input as public comment instead of having a separate meeting. I think about past rankings that we've done, and when we're talking about it, we usually have some public comments that come up along the way over those 2 months that we're trying to figure that out. And then when it comes to the public hearing, as Nate noted, there's only 1 or 2 people who are signed up. But along the way, we do get feedback. We get feedback when we're getting presentations or we're inviting speakers in to tell us more about this. I think of some of the changes regarding child pornography, I think is an example of that, where the people showed up and did give public input as a regular meeting. So I think there's history of that. And if there's an opportunity to informally change or to change it within our own policy, that's a good move.
Commissioner Lai?
Thank you, Madam Chair. So 3 comments. First, I think the discussion probably is reflective of what we would be doing at our next meeting, right? Because we're kind of getting into the weeds about some of this stuff. So I think that's good, and I think we should do that. And pardon my legislative ignorance to the math process here, but I'm just curious about 2 things. I'm wondering, do we have to have the annual public hearing that's currently on here, like in that November 29th, December 5th timeframe? Could that be earlier, which I know kind of backs everything up earlier? I mean, we've got the exactly 4 weeks, exactly 4 weeks, exactly 6 weeks. But if everything else gets bumped back, could we do that? And then that ties into a question I have, and this is probably a big ask, is that typically the guidelines publication is August 1st, but could we actually make a request that it's actually September 1st or September 15th, something like that, whatever. But that gives a little bit more breathing room as well, especially if there is a special session, and we don't have to necessarily rely on an ad hoc basis per session to get the permission to delay something beyond August 1st, that it's actually baked in or embedded into the statute, that it's not August 1st, but and I said September 1st or September 15th, it could be even mid-August. I know August 1st is a nice date and we're used to it, but maybe that's something as well. So I think those are some things I'd like to think about differently.
Yeah.
That if those deadlines were changed, maybe it would kind of be a domino effect to change other deadlines. Does that make sense?
Yeah.
So that's just my thoughts on it.
Yeah.
And I do not do legislative math. That's
So-
somebody else's bailiwick.
And Madam Chair, can I
Yes.
respond to that? So on your first comment, that's just a matter of us figuring out the calendar, and
Yep.
we can noodle with that all day long, and I kind of enjoy doing that. So we could probably work with what you're suggesting. The second issue is, a legislative issue is, I think, and maybe I'm just restating the obvious, but the legislature typically makes criminal law changes effective August 1st of that year. And the statutory default date is August 1st. If they don't specify an effective date, it is August 1st. So what you're suggesting there would be a bigger muscle movement than anything else we're
I
discussing.
understand,
It wouldn't be
yeah.
just within this
Yeah.
room. It would be, the legislature would have to change the way they do things.
Yep. I get it.
Yeah, I don't actually disagree with talking about that either.
Well, it just seems that in
Yeah.
long before I was on the commission, just generally living sort of this out in my daily practice, we've had a lot of extra sessions, right? That don't end. We've had special sessions and all this kind of stuff. And I just think that looking at the timelines, it's very, very compressed. It's important work. And I would hope that everybody would want this body to have enough time to do that important work and not in rush, because this other process, through a delayed process, took more time than they're supposed to. But I'm just saying, I just think that there should be some default provision to give us that additional time too, so that it's not, because I just think it's kind of an unreasonable ask for us to do the important work that needs to be done on such a short basis. So I get that there's a lot to that deadline change, but it's something to think about.
Yeah, what I was just gonna say, like, a couple years ago, we had like a massive change that we had to do in like a week. So, yes,
It was
that was fun.
2021, yeah.
Commissioner Knudsen.
This is just downright complicated. I mean, that's-
Isn't it?
So it just seems to me that we can say, we're gonna have a meeting once a month. Well, what day is it gonna be on and what number of the day of the month is that gonna be? And as things come up, we can say, well, this year we've been working for the last 6 months on this issue. Let's set the public hearing to coincide with this regular meeting. And maybe it's always the November meeting. We just say that's also a public hearing. But at least we're going to, people will know for our own schedules and our sake. But this is downright, the second Thursday, well, then next month's the third Thursday. Then the next month it's a Thursday after the third Friday, and then the next month it's a Thursday after the third Saturday. Next month it's a Thursday after the third Monday. And, we've got so many parameters, we're not gonna be able to satisfy all of our parameters with respect to the legislative session, the effective date of new laws, and then our concerns. I'm advocating for whatever public hearings we should have, and we can designate them months or year in advance. And they could coincide with the regular meeting, and we could push those agenda items from that regular meeting into the meeting before or after, but.
I'll let Nate respond to this more formally. The reason that it doesn't quite work that way is because there has to be a certain amount of time to get it published in the state register, and then a certain amount of time until the hearing can actually happen after that happens. And then we have to meet at least a week late. We have to keep the record open for 5 days, then meet a week later. So like if we threw a public hearing onto a normal date, that's fine. But then we'd have to have special meetings to act on that further down the road. So it's like, it doesn't fit neatly into the once a month.
And these are
Calendar.
our adopted procedures.
Exactly. Yeah.
And let's change our adopted procedures.
That's what we're talking about. Yeah. I agree. Go ahead.
Madam Chair, so, I mean, we've been talking about changing our adopted procedures with respect to the summer meeting.
Right.
But I think what Commissioner Knudsen is suggesting is changing our adopted procedures with respect to the winter meeting also, to maybe still have a more formal process than the summer meeting, but not quite as formal as we have now, so that we can fit, so that you could say in month X, hey, let's have a public hearing, and then have the public hearing at the regularly scheduled meeting time in month X plus 1, the following month. And I think that's kind of a fun idea. I hadn't thought about it, but I think that's also within the possibility of administrative rulemaking, which is the question, should we go down the path of administrative rulemaking?
And then we could
Yeah.
respond to the public meeting at our next regularly scheduled meeting.
And we have had complaints before about the complexity of our meeting calendar. We had a complaint one time, one legislator suggested that we were, trying to meet at unusual times to make it hard for the public to follow what was going on, which is, I assure the public, is not the intent.
Well, I think like we end up at the same place, and I don't actually care what the answer is. I do think like our own procedures have put us in this box, right, where it's very difficult to be nimble and to do what we need to do in the time that we have. So reviewing our administrative rules and our procedures, to me, is the next logical step. So, and then once we figure that out, that leads to what does our calendar look like? Is it just once a month, whatever? Commissioner Middlebrook?
Thank you, Madam Chair. I just have a couple questions.
Mhm.
One is if for the remove the summer public hearing and go to more of the informal public comment on those changes, anything that comes from the legislature, we have to change our administrative rules, right?
Yes.
For any of the other scheduling things and the basically annual public hearing that's normally been in December, we don't need to change anything with regard to any of those.
Well, if we want to have different timing, we do. Because all that timing that we were just talking about is in our administrative rules.
The 6 weeks, that time period, the notice and all
It's like
that,
the 4 weeks, right?
4 weeks for notice.
I can't remember now.
So the reason for the 6 weeks is that there are two requirements that are in our administrative rules.
Okay.
And that's the only source of them. The two requirements are, number one, notice has to be published in the state register. So that takes a week and a half because the deadline for state register publication, so we meet on Thursday, the deadline I think is the following Monday or the following Tuesday for the next Monday. So if you're following that, we meet on Thursday, it's 2 Mondays from there,
Okay.
it gets published. And so that's number one, that's in our rules, that it has to be published in the state register, which is, I don't know what the circulation is at the state register, but I don't know that a lot of people are reading it. And then the second is it has to be in there for 30 days
Oh, right.
prior to the time that we can decide on it. And that's, you total all that up and it works out to 6 weeks.
Okay, so,
Yes, Commissioner
all right,
Middleton.
thank you, Madam Chair. So just to follow up on that, so if we would change our administrative rules and also look at whether or not it should be published in the state registry, which I have a feeling not many people look at, they're looking at our website or they're looking at something else, then we could figure out and do the schedule better. The second question I have goes to Commissioner Ladd's comment about changing the August 1st date. My question there is, does that to me seems like it may be a bigger problem where the new laws go into effect August 1st. And if we are changing our date to September, won't there be that time period where things are a little bit uncertain for the practitioners? And since the laws will have gone into effect, but the guidelines won't have gone into effect. So I guess that's kind of my concern if that's what would happen. Or would we have to get the legislature to agree that none of the new laws go into effect until September?
That was my question, or my point, was that instead
Good
of
luck with
saying
that.
it's effective August 1st, it's effective September 1st. And I get that might be a big ask or an impossible ask, but that was my point. Not that we would have that gap where we would have effective dates and there would be that limbo time. I wasn't suggesting
Okay.
that, yeah.
Yeah, so that would be a much bigger lift.
Yes.
To convince the legislature to give us time.
Unless the special sessions, we were able to do that with that second,
Right,
then we were able to get them to do that, but
right.
every year, I don't know.
Even in that special session, matter of trivia, there was a bill that was in a different omnibus bill, a crime,
Oh, that's right.
and that started August 1st. So even that year, we didn't have complete success with September 15th.
Okay.
Okay, so I think that I'm hearing general agreement that our procedures are making things a little harder than they need to be, and that there seems to be agreement that we should look at them and potentially move forward with creating them. Your favorite part is actually going to be that we're supposed to notify people by US mail of our changes. So that's the best part of our rules. That's how long it's been since they. Anyway,
I think the internet was about a year old when our rules were written. So
yeah. So we might want to update that too if we look at the rules. But okay, so what I don't feel like we need a motion to do that unless you feel like we need a motion.
no, it's just a matter of us setting a future commit. So it sounds like that'll be a worthwhile subject for a future meeting agenda.
Yes.
So
Yes.
um,
And then, yeah, I was just gonna say, like, do you have a sense of what that process looks like for us? Since we haven't done rulemaking since the 1980s.
to serve conserve work. I did not look into that. I was kind of waiting to see whether that was the sense of the commission. And
Okay.
it looks like it is. So I will look both into letting you know what the rulemaking process is, but also kind of focusing on what do our rules say now and what are some things that how they might read differently. And based on this discussion with Commissioner Knudsen, I'll not only look at, I was sort of assuming that we would keep the formal process in place for this winter meeting, but I'll look at possibly changing that as well. So
Okay.
I think that's a really interesting idea.
Commissioner Knudsen?
All with the goal of having some kind of predictable, regular
Yeah.
meeting schedule.
Dare I ask, do you have a suggestion for what that would be? Like the blank Thursday of the month?
Well, the staff started out with the first Thursday of the month. I mean, if that seems, that makes sense to me.
Like that?
Okay.
The first Thursdays of every month, that's always a really nice day.
You're gonna lose that desk time now, because that was your, probably like, oh, I can get stuff done
Right,
today.
yeah.
It's empty, right? You just blew that. Okay.
All right.
All right. So yes, so we will clear the dust off of our administrative rules and open them up, and the cobwebs will come with it. It'll be a fun little challenge there. See what we can do there.
And Jim, one more-
Commissioner Knudsen.
And I think we would be remiss in not thanking the staff for going through this and making it so complex, which it needed to be in order to comply with our procedural rules and things.
Yes.
And I think it just points out the other action we needed to take, but without this, we wouldn't have taken a look at that. So staff's efforts are noted and welcome to get us to this point.
Absolutely. And I can't go past that comment without going back to Commissioner Moore, because at some point you actually talked in terms of second Thursdays and things. And I was like, how do you know that? You know, like, I don't even know how you understood that this was like the third Thursday minus 2 days, except when there's a full moon. I mean, it was very, crazy. All right. Okay, so we will take a look at our rules. We'll look at what we can do to streamline procedure, retaining public process. And the main, as we do all of these discussions, we have to keep in mind that the goal is to continue to have a robust public input process, which we do now. So we're not going to change that. Okay. Item number 6, legislative updates. Over to you again.
All right, thank you, Madam Chair. So this legislative update is a little different from the two that I've given you previously this session. It's really just focusing on one bill in both the House and the Senate, the Public Safety Omnibus Budget Bills. So this is the bill that funds the Department of Corrections, funds the Minnesota Sentencing Guidelines Commission, and other significant entities. I know at least, I think it funds the judicial branch too, at least in the Senate. I'm not sure if it does in the House.
That's correct.
But as part of that, it has a number of crime bills because at least in theory, those crime bills have budgetary implications and, specifically in terms of prison bed costs. So they're also included in the bills. So this is really limited just to those omnibus budget bills. Both of those budget bills were passed in the last week of March through their respective committees of origin. The Senate bill has now made it through the Finance Committee, and I believe it's on its way to the floor. So I don't think there are any other committee stops for that bill. So there is.
Oh, it doesn't have to go to another finance committee in the Senate?
I think it went to the Senate Finance Committee yesterday.
Oh,
Yeah.
did it?
And
Okay.
it was amended, so, there will be a second engrossment for the Senate bill. I didn't have a copy of necessarily all the amendments in advance, so I don't know for sure if there are changes to these, but just from hearing the descriptions of those amendments, it didn't sound to me like there were a whole lot of substantive changes to the policy. So, so I think this is all fairly accurate still on the Senate side. On the House side, this just got engrossed yesterday. So I'm assuming it'll be on its way to the House Ways and Means Committee soon. Before I get into that though, let me just tell you about what's not going to be in this. Sports betting and cannabis are both very large bills that will be traveling separately. And both of those bills have in common the partial legalization, the partial regulation, and the creation of new crimes regarding sports betting and cannabis. So there will be work for us to do if either or both of those bills ultimately gets enacted. And the cannabis bill is heading to Ways and Means on the House side. So it's approaching the finish line on the House side. So it's possible that the legislature will take action on the cannabis bill this year. There are also 3 laws that got passed. So these are finalized laws, chapters 14, 15, and 19. And 15 is the one that I described to you earlier that establishes felony crimes for possessing, purchasing, or acquiring multiple used attached catalytic converters. I think 3 or more is the felony threshold, unless there are certain conditions met. So it's not automatic contraband, but if you have a used attached catalytic converter, you have to mark it and so forth, or else it is contraband. Let's begin with the omnibus budget bills. So these are in order, not of importance, but in order of how they arranged in the House bill. But maybe of importance is the first one, which is fully funds our agency. So we'll keep going. But not only that, it also funds an inflation adjustment that the governor asked for, and all 4 of the change items that we discussed with you last year. Both of these are in both the House and the Senate bill, so it looks very good for those change items, which is the most significant one from your perspective, in my opinion, is the comprehensive review of the sentencing guidelines. So that's going to be huge in terms of the work of the next commission. By the next commission, I'm talking about the fact that the governor hasn't reappointed or appointed commission members yet, but we do expect that to happen later this month. Still, I haven't matched up what the appointments are that the governor's made so far in terms of what the governor's hoped for schedule was. But I'm under the impression that the governor's on track, and the schedule was to appoint Sentencing Guidelines Commission members later this month. So I'm expecting that in May we will have sort of a new Walls Commission. And that's going to be that commission's job, is to begin a comprehensive review of the sentencing guidelines. And I should say, a lot of these you'll notice are only on the House side, not on the Senate side. Senator Latz, who's the chair of the House Senate Judiciary Committee, said that he intended to have a pure policy bill that's also going to be an omnibus bill that doesn't have budgetary implications. So that has not been released yet. I don't know when that will be released. So that's why you'll see some that are only on the House side. I think we talked about just about all of these. I don't recall if we talked about bias crimes before, but there would be an expansion to biased crimes, which if that gets enacted, that's both in the House and Senate. If that gets enacted, we've got to think about the commission. The commission also has an aggravated factor if the crime is motivated by bias. So typically the commissions match that up with the legislative language. So that'll probably be something that the commission will look at changing if that gets enacted. Labor trafficking, we've talked about that before, but the news on that is both the House and the Senate have now passed this as a standalone bill. So even though this is mentioned in the omnibus bill, it's now been passed by both the House and the Senate. I don't know, I think the language is a little different. So there may need to be a conference committee, or maybe they'll just accept the other body's language, but that's definitely moving along. Organized retail theft, I want to talk about this. This was one where we had a 58 bed increase, and we had discussed this. Officer Ibrahim had some interesting points when we discussed this in an earlier meeting. The Senate bill has really tightened it up quite a bit. So the Senate impact would be down to 5 prison beds, according to our estimate. The Senate version would require the organized retail theft to I'll say, without an intent to be sarcastic, would require it to actually be organized. So there's really not an organized requirement in the House side. It just has to be essentially shoplifting for purposes other than using it. So shoplifting to return or to resell would be considered organized retail theft, even if it wasn't organized. But the Senate version would require the act to be part of an ongoing criminal enterprise with 2 or more participants and repeated acts. So definitely tightening up the requirements quite a bit to where it really looks like organized retail theft, and that decreases the prison beds dramatically. Interestingly, they didn't ask us to do a fiscal note to change it. So there should be some good news on the money side once our reduced bed impact hits the fiscal bottom line. The burglary for shoplifting within a year, that was an 11 bed reduction. It was pointed out to us an error that we made in the fiscal note by House staff. We missed a couple of little words in a difference between the bill and something that we were using as an analogy. So we're going to have to downward revise that. Let's see, I think. So let's talk about House File, the House Budget Bill, Article 4, Sections 1 and 2. So this would change the membership of the Minnesota Sentencing Guidelines Commission. It would take away the Chief Justice's appointment authority, which right now the Chief Justice appoints 2 members, the Court of Appeals member and the District Court Judge member. And that authority would go to the Chief Judge of the Court of Appeals and to the Judicial Council upon recommendation of the Minnesota District Judges Association. It wouldn't change the designee, which is Justice Moore right now. It adds 2 new members, a treatment provider member and an academic member. It expands the crime victim public member. So it could either be a victim of a felony crime, as it currently must be, or it could be a victim's advocate. And it requires one of the 3 public members to have been discharged from a felony sentence. And it institutes staggered terms, beginning with the commission that's appointed in but basically Governor Walz's successor would have to appoint staggered terms. Not meaning to imply that Governor Walz won't get elected for a 3rd term.
Is he running?
I have no announcement.
This is not the place it would happen either.
No, not like that. No. I'm just saying, when I say Governor Walz's successor, that could be Governor Walz. Let's see. This one we talked about, this provision codifies the sentencing guidelines presumptive 5-year probation cap and makes it non-waivable. Right now it's waivable under the sentencing guidelines. It also applies it retroactively. It also changes the exclusion list. So right now the exclusion list just has homicides and criminal sexual conduct offenses on it. This would also add stalking and harassment to the exclusion list. There's a 9-member clemency review commission that would review applications and provide clemency recommendations to the Board of Pardons. So this one's interesting. There's an indeterminate sentencing release board that would grant release, supervised. It would grant supervised release rather than the Commissioner of Corrections alone. So right now, the Commissioner of Corrections has sole authority to grant supervised release or parole. The indeterminate sentencing release board would have that authority. So there's no fiscal impact because it's not changing how one gets released. It's just changing who has the authority to do it. The decision would be devolved to a 5-member body. But on the Senate side, it calls it a supervised release board rather than indeterminate sentencing release board. And it has a significant prison, about 23 bed impact because it deals with juveniles with long sentences. So anybody who committed a crime under the age of 18 who's serving a sentence that's longer than 15 years, whether it's a life sentence or, it's 2 consecutive 10-year sentences or one 14-year sentence or whatever it is, or one say 20-year sentence, any one of those people would be eligible for early supervised release after having served 15 years in prison. And it would apply retroactively to people who are currently serving long sentences. And that supervised release board would be the same 5 members on the House side, plus there would be 2 additional people when making these juvenile considerations. And both of those new people would have to be experts on juvenile neurological development. And the 7 members of the board would make those release decisions. I think that's an interesting bill. House File Article 10 and the Senate Article 7 are the Minnesota Rehabilitation and Reinvestment Act, which you've heard about before, which allows cancellation of 1/6 of the total executed sentence and or abatement of 1/3 of the supervised release term if the prisoner or releasee complies with an individual rehabilitation or supervision plan. So I thought this was interesting. The paraphernalia bill, it legalizes drug paraphernalia possession, which was kind of all that we heard about in the committee. But what I think is interesting is the other thing it does is it excludes possession of a residual drug amount contained in drug paraphernalia from 5th-degree controlled substance crime. Now, I think different jurisdictions have very different amounts, and what they do, say somebody has a meth pipe, and the meth pipe has not been washed very well, let's say, and it has a residue of meth on it. In some jurisdictions, that will be a paraphernalia misdemeanor charge. In other jurisdictions, that will be some amount of a controlled substance, and they'll be prosecuted under felony 5th-degree controlled substance crime. Having said that, there's now a law in effect since 2016 that says that a small amount of marijuana or a small amount of one of these substances, if it's below a small measurable quantity, is a gross misdemeanor 5th-degree controlled substance. But that's only for first-time offenders. For non-first-time offenders, it's still a felony, even under current law. And this law would take all of those cases, if it's a residue found on drug paraphernalia, it would take all of those and make them non-criminal. I don't know if police could wash the pipe before they gave it back to the defendant, but it would no longer be a crime to possess the paraphernalia either. And I think that's interesting because it probably has a fiscal impact, but we were not asked to do a fiscal note on this. So that's why you haven't heard about it before. I think Ann probably has data on residue, or at least trace. I don't know if trace is different from residue necessarily. But there you go. And then the final item, I don't really know much about this. The House has an article and the Senate has an article on implementing various reforms in community supervision policies and funding. And I know that there's a new funding formula out there. And that's really all I know. This is not my area of expertise, Madam Chair, but perhaps there's someone on the commission who can illuminate us a little bit more on this.
I'll start, and then if Commissioner Estrada wants to say anything, she can. I asked Nate to include this because it's a pretty significant piece of legislation. I can tell you, I didn't have a chance to look at what the Senate, like how closely the Senate version matches the House. I think they're the same, but there's been so many changes that I had no idea. But this is definitely a big year for community supervision at the legislature. The legislature is contemplating a significant funding investment for community supervision. Part of that investment is to establish a new, revise the funding formula. I don't know how much you all know about this, but the funding is given to DOC and passed through DOC to the counties for probation. there's been a formula in the statute since the community supervision was set up, but the legislature has not funded it up to the level that the law required in recent years. So this sort of tries to do that, and also changes the manner in which the funding is allocated. And I don't profess to know what that formula is. The more important thing in my mind is that the legislature is really seriously contemplating significant investment in community supervision. And I thought we should be aware of these changes just because how community supervision works, how probation works, how supervised release works, has really been a significant part of our conversations in the past few policy discussions. So I think it's important for us to understand what's happening out in the field. A couple of other sort of key points from the legislation that I know for sure in the House side, I think they're in the Senate side too. There's also recognizing tribal governments as a potential provider of supervision services. They have to conform to the same rules and structure that counties do, but opening the door for supervision by tribal officers. There's more structure around the comprehensive plan. So, the DOC sends the money out. They require a plan to be sent back to them about how is this money going to be used. There's more structure put around that. Some enforcement mechanisms to make sure that policy changes are sort of happening throughout the state. The laws also require standardization of data collection across probation departments, and requires the DOC to do annual reporting on probation so that we would understand population size, violations, revocations, and early discharge. Right now, the data exists in our state, but it's not accessible. So this would require DOC to start reporting on that. But after, it's also requiring the counties to, agree on the definitions of all of those things as well. And then the law is establishing an advisory committee to help develop standards for probation and supervised release. So that's another piece of it. There's a lot of other changes in there too. It's a pretty big piece of legislation. So I don't profess to be the expert on it. But I think it's something that we just want to keep being apprised of as this moves forward. Is there anything that you want to say?
No, Madam Chair, I think you covered it.
All right. Any questions on that? Or any questions on any of the legislation that Nate has gone through today? Do you have anything else for us on that?
Not without leading into the executive director's report.
All right, well then let's move to the executive director's report.
All right, thank you, Madam Chair. So I did just look on the website at some of the appointments that the governor announced on the 10th of this month, and compared them to the calendar that the governor's office sent out last fall. And it looks like the governor's doing a pretty good job. The governor's office is doing a pretty good job of staying on track. These appointments were intended to be appointed either in March or April. So at least the ones I sampled. So it looks like I'd say there's a decent chance that we'll have a new commission by the May meeting, but it's possible we won't. My hope is that we would have a new commission, and if so, I'd kind of like to trot out the catalytic converter crime as sort of your sample crime. I'm expecting to have a busy June meeting, Madam Chair. And especially if they're new commission members, I'd like that not to be their first time looking at, say, a ranking decision. So what I'd like to, and I'm sorry, I should have talked to you about this first, but what I'd like to do is give the commission a chance to take some time with the ranking decision, just as a sample. And if we don't have time for that on your agenda in May, we can always do it in June. But it might be nice if there's a new commission. to have a chance to look at that. Otherwise, as I think we have announced previously that, you know, we received the Kern Award, which is a very prestigious sentencing award last year, and it was published in the Federal Sentencing Reporter, and that is included in your materials. I will say for members of the public, we didn't include it in the materials. We included a link where you can obtain it if you have a subscription or purchase, but for copyright reasons, we didn't include the entire article, but it was in the commission meeting materials. That concludes my report, Madam Chair.
That was great. Yeah, I guess I'm a little, just to talk out loud, looking at the number of bills that it appears the legislature is going to act on, we are going to have a lot of work ahead of us for ranking decisions. So I think the other thing that I would maybe task you with thinking about is whether we need any additional input on any of these bills, you know, to help us with ranking. You know, I have not followed these bills, and maybe not everybody here has. So, yeah, I just don't know how difficult they're going to be for us to get through. Just food for thought. I have to think about whether there's places where that would make sense.
Yeah, I'm thinking about 2021, and we did pre-discuss the issues in the June meeting. I don't think very many of those issues we were looking at for the first time in 2021.
Yeah.
2021 was also a doozy. But that was also the delayed one, wasn't it? So we probably had a chance to look at it in June, and then we'll look at it again in July.
Probably.
Yeah. And it may be that we have to meet for longer than just an afternoon, or maybe we start at noon or something like that in June. But it looks like the legislature is going to have a very productive year this year. So.
For sure. Yeah. Yeah. And I think too, well, we'll see if we get our appointments, but just to sort of a refresher for the full commission, we have several new members who haven't potentially been through this process before. Just sort of a refresher on how we do that and what we look at as guiding principles. So I think that's what you were thinking of with the catalytic converter, was sort of using that as a application.
Yes. And that's if we have the new members by then.
Yeah.
It might be close. If we don't, I guess we can discuss offline, Madam Chair, what you'd like the agenda to look like.
Okay. Commissioner Middlebuck, did you have something
Thank
to
you,
add?
Madam Chair. I agree. I would agree with the director as far as if there are any of these bills where they're, you know, looks like they're coming through, to get a head start on them, just to even get some information and just start discussing. And I guess closer to the next meeting, you'll know, right?
Well, I expect by the next meeting, these bills will still be in conference committee. So, but yeah, particularly those that are same or similar, which I think there's going to be a lot of that.
Mm-hmm.
Yeah, no reason why we could get a head start on that.
Yeah, that makes sense. All right. Any other comments, questions? Okay, then I think we can move to public input. Unless you look like you might have a.
No, I wouldn't. All right. So, members of the public, at this time, you should be able to raise your hand. If I'd ask staff who are members of the public if they could raise their hands just so I can tell it's working. All right. So I'm assuming that you can all raise your hand except for the call-in user. So I will unmute the call-in users. Number starts with 218. At this time, anybody else who'd like to be participate in the public discussion, please raise your hand now. All right, unmuting the call-in user. So the call-in user's number starts with 218966. Can you hear me?
Yes, I can.
Do you have a public comment?
Yes, I guess I would just like to say thank you to the commissioners who served. I heard a couple of them were stepping down, so I just wanted to say thank you for your time. And while we may not have always agreed on a few things, I do want to say thank you because throughout this journey of since I have been attending these meetings, I have learned and grown, and it's actually been very enriching for me. And it's always good to keep an open mind and see multiple viewpoints and try to come to a conclusion and try to just better society. So I just wanted to say thank you to the commissioners for their time and service on the board. And yeah, I just look forward to being able to hopefully work with you guys in the future and attend these meetings. So thank you.
Thank you so much for your comments. Before you get off, can you identify yourself for the record and then we can properly acknowledge your comments?
Oh, I'm sorry. This is Michelle Hipsig, HIPSAG.
Excellent.
Thank you. I really appreciate the comments.
All right. Thank you.
Madam Chair, no one else has raised their hand, so not seeing any hands. So it appears that ends the public comment period.
All right. Well, thanks everyone for coming today and having a complex discussion about procedure. That was fun. I'm looking forward to seeing you guys over the next couple of months. Looks like we have a lot of work ahead of us. So get ready because we will have to buckle down and really put our thinking caps on over the next couple of meetings. Again, thanks to our outgoing members, Commissioner Estrada, who's here, Commissioner Hansi, who was unable to be with us today. Really wonderful to have you on the commission. With that,
Thank you, everybody.
I will adjourn the meeting. Thank you. Mm-mm.